The unions lose. Now, since Congress passed this, every president except President Biden has issued executive orders excluding certain agency subdivisions. Everyone's done it except Joe. In assessing retaliatory motive, the lower level judge pointed to statements in the fact sheet. He says, well, that was really mean to the unions. They're good people. The government is going to suffer irreparable harm if there is not a stay. That is a shift, man. The Trump DOJ scores another victory, and the unions lose. This one's coming out of California in the Ninth Circuit Court of Appeals. We've had a lot of battles in this jurisdiction, and they're validating another district like the DC district, which is also finding in favor of Trump, as we've talked about here. Now, the unions have been suing all over the place. They say, we're civil servants and we need a union. Not only are we basically unfireable from the government, but we need a union to fight for our rights and benefits. When they're part of the biggest union in the world, which is the federal government, they all got together. You've got the AFL-CIO, American Federation of Government Employees, the national nurses, all of them. They all got together. They sued. Remember this? And they sued the OPM and they said, wait a minute, you can't interfere with our unioning. We're the backbone of this country and we can do what we want. And they have for a long time, not anymore. So now the Ninth Circuit came back down, and it's not a too extensive opinion, but here's what they tell us. In a per curiam, an opinion of the court, they say, all right, Trump's DOJ is here. We had some loser judge, maniac, down here in the lower level court, probably Northern District of California. Maybe he was Judge Alsup. We don't know. But here, the United States seeks an emergency stay of the lower level judge's injunction, saying Trump's executive order is invalid because I'm the president now, said the lower level judge. And of course, this was the executive order exclusions from federal labor relation management programs. And Trump basically kicked them out of this program. You're gone. That excludes certain federal agencies and subdivisions from collective bargaining requirements based on national security concerns. Like, we don't have to deal with your union crap. We grant the government's request for a stay of the injunction pending the appeal. Trump DOJ wins. So lower level judge was wrong. You're stayed. Trump has the power. Congress enacted this statute. It's called the Federal Service Labor Relations Statute as part of the Civil Service Reform Act. This begins a series of congressional findings. They say, well, this is back in 1978, different era, says it begins with a series of congressional findings. All they came out and they said, well, labor organizations and collective bargaining in the civil service are in the public interest. So we can allow bureaucrats to form more bureaucracies to protect their first bureaucracy. Okay, it's just layers. Like, you go to the government, like, they don't fire you for basically anything, as we've seen. You can be on the Secret Service team and be responsible for getting the president shot in the head. Just a little suspension. Just try harder next time, okay? Don't screw it up. Crazy times. So you just can't get fired. And then they form these unions that have massive backing from Democrat entities because they just support all of their infrastructure in the federal government. And they've got money. They file lawsuits. They act as a lobbying arm for these people. How are small businesses or individuals who are opposed to those issues supposed to organize? It's very difficult. And when the federal government carves out exclusions for them and gives them special benefits, now you're even harder pressed to have a fair interest in your country when you're arguing about policy, because they have special access to the government. Now, to that end, the law guarantees federal employees the right to join labor unions, which, okay. And it requires unions and federal agencies to negotiate in good faith over matters involving conditions of employment, and requires all collective bargaining agreements to include procedures for filing grievances to make sure it's nice and cozy for the bureaucrats who already get like 1,000 days off. Notwithstanding Congress's findings about the benefits of collective bargaining, the law exempts several federal agencies from coverage, including the GAO, the FBI, the CIA, and the National Security Agency, Tennessee Valley Authority, and the Secret Service. Can't have unions over there, apparently. Now, relevant here, the law says the president can exclude additional agencies from dealing with unions in the union way. Now, the law says if the president determines that the agency or subdivision has a primary function of intelligence, counterintelligence, or national security stuff, then the president can say that this cannot be applied to that. Now, since Congress passed this, every president except President Biden has issued executive orders excluding certain agency subdivisions. Everyone's done it except Joe. So there's precedent for it. But the lower level judge apparently forgot about all of that. On March 27th, Trump issued Executive Order 14251, which invoked this provision of the law, and it excluded entities that include now the State Department, the DOD, the Department of Justice, the EPA, the FCC, the Department of Treasury, Energy, Agriculture, Homeland, Interior, Health, and Human Services, and the Social Security Administration, all your union deals, deleted. Now here, the order contains exceptions for local employees who are employing agency police officers and doesn't apply to the Bureau of Prisons and more. But on the same day of the order, the White House issued a fact sheet, and the fact sheet stated that union activities impaired agency functioning in a manner that could undermine national security, including the unions stopped the removal of employees for poor performance or misconduct, right? You can't fire them. Unions like, we'll sue you for that. Says the fact sheet also noted that the law enables hostile federal unions to obstruct agency management. We've seen them. They're suing. They're doing it right now. They're suing right now. Like, here's an example that certain federal unions have declared war on President Trump's agenda. They've been doing it all over the country. The OPM guidance explained that the order could improve agency functioning because collective bargaining agreements impeded the separation of poor performers, can't fire them, the issuance of return to work policies, and reductions in force. And you see this like with cops all the time. Like, you have these bad cops. Like, there's a lot of cops are very, very good people, good cops. They're, nice families and doing good stuff. But there's a bunch of crap cops too. And there's several of them, who have like multiple violations and they get a reputation in the departments. And other cops know, like, that dude's kind of a bad dude. Prosecutors kind of know that dude's a bad dude. Like, and you can watch it. Like, when you're dealing with prosecutors, they'd be like, who's the cop? Like, they know the cops by their reputations, and so do the defense attorneys. And so the prosecutors, you'll see them like looking through the file. You're like, hey, I want a plea deal on something. This guy got a DUI for whatever, and I want a plea deal. He should have a reckless driving charge because this, the whole case is messed up. Prosecutors sometimes won't even read the actual evidence in the case. They'll look at the BAC, blood level, flip through it, don't care about the facts, don't care about the traffic stop, don't care about really anything. They look at the cop. They just look at the cop. Oh, okay. Well, yeah, we might be able to work on that. Sure. Yeah, we might be able to do something about that because the cops are just a disaster. And it's a good tell. Like, if you're a new attorney and you see, like, where are the prosecutors looking in their files? And a lot of it's now digital, but when I was, coming up, actually a lot of it's still paper, but it was a lot more paper. You could like see them, like they go right back down to the signature on the ticket. Tim. So here, and then you can't fire them. They just exist forever. Or when they leave, they voluntarily separate. They go hang out for a couple months, get their severance, and then go get a different job in another county over. And they just hire them back on over there. It's like this revolving door. On April 3rd, plaintiffs, 6 unions representing over 1 million federal employees, sued the president. 1 million federal employees who are a part of the federal government, the biggest union of them all, now have 6 unions who all sue. You know how much power that is? The federal departments and agencies saying that you're now cut off. Their suit said that this violated First Amendment retaliation. They're violating our First Amendment to have a union. It was ultra virus, outside the law, violated Fifth Amendment due process, just like they say about the illegals, abrogated contractual property rights in violation of the Fifth Amendment. Like, in other words, they were entitled to these benefits and to these union deals, saying they violated the equal protection of the Fifth Amendment, arbitrary and irrational classification. There's a whole fact sheet that explains. So then on April 7th, they filed an ex parte motion for a TRO, which the district court later construed as a motion for an injunction. And in response to this, the Chief Human Capital Officers Council, an interagency forum led by the director of the OPM, advised the agencies don't terminate any collective bargaining agreements or take action to decertify these. All right. So as soon as the injunction came down, they stopped firing people. So then the district court granted the union's request, obviously, California, June 24th, ruling only on the First Amendment retaliation. They said that's the strongest claim. The lower level judge said, in the Ninth Circuit, a plaintiff can satisfy these standards by showing a likelihood of success on the merits if there are serious questions about the merits and if the balance of the hardships tips in favor of the plaintiffs, these unions. It's going to be very hard for them to have to go get real jobs. The court concluded that plaintiffs demonstrated a serious question as to whether the order retaliated against plaintiffs for filing lawsuits and issuing public statements critical of the current administration. So the unions attacked Trump. He issues this order, looks like retaliation. And so we have to presume it's retaliation. We can't presume that it's his lawful power being exercised after a proper election by the American people. In assessing retaliatory motive, the lower level judge pointed to statements in the fact sheet. He says, Well, that was really mean to the unions. They're good people. Expressing a view hostile to federal labor unions and their First Amendment activities. Nobody's saying they can't speak, you maniacs. They can post whatever they want, wherever they want, say whatever they want to whomever they want. They don't have the entitlement to have a certain contract with the federal government that entitles them to a bunch of rights. These include that the statement that it enables hostile federal unions to obstruct agency management, which is what's happening literally in this lawsuit. That certain federal unions have declared war on Trump's agenda, that the largest federal union describes itself as, quote, fighting back against Trump in favor of their Democrat constituents who are sucking off the teat of the American public, and that the President Trump supports constructive partnerships with unions who work with him but will not tolerate mass obstruction that jeopardizes his ability to manage agencies with vital national security missions. Now, the district court reasoned that such statements called out federal unions for vocal opposition, and Trump is condemning the unions because the unions are condemning the president. Now, although the district court lower level judge disclaimed any intention of second guessing the president's national security determinations because that would make him the president, if the judge can say, actually, your fact sheet is wrong. And actually, the EPA is not a national security agency. And so we can have collective bargaining with them because all we're trying to do is save the planet. And that's not national security. Well, that's the judge substituting their judgment in for the president's. That's unconstitutional. So they sidestepped that, the same pattern we've been seeing repeatedly here with these filings. It noted the government itself had a hard time saying why it excluded certain agencies. And so it might be properly regarded as having a mission of national security. And he said, well, some of these, they don't seem like national security agencies, like the EPA. What? Well, if China is launching space weapons and it's impacting our environment, maybe the protection agency of the environment needs to be apprised of that. The court treated this as evidence. Well, there is a serious First Amendment question, but maintained it would not sit in judgment of the president's national security determinations while literally sitting in judgment of the president's national security determinations. Crazy, right? With respect to the remaining preliminary injunction factors, the district court then concluded that they showed that there's going to be irreparable harm. These unions are going to be just so devastated based on the threat that they're going to have in reductions in allotted dues, okay? And the federal employees get paid by the American taxpayers, and the unions skim off of that for their own coffers and then go file lawsuits against the administration on behalf of the federal employees. No more. The loss of collective bargaining rights and weakened support for unions. Well, they deserve it. If they produced amazing things and we could all look at it and say, oh, wow, like SpaceX was built with unions. Wow, it's amazing. Really good for like incredible productivity in the world. Or like, wow, Amazon is like really built by unions and everybody benefits from that. And you might not like Amazon, but a lot of people get a lot of value from that, from Amazon. And was that unionized? Or what are these unions producing? What are these government unions producing? What has the AFL-CIO ever produced other than government? And I don't know what the government produces. I still have a hard time understanding what that is, other than spending or real value in American lives. Everybody else produces something. Even if it's a show, it's a live stream, okay? There's actually something tangible on the other end of that. What are the government employees doing other than just kind of pushing papers around in many instances? And when you find the people who are, you can't get rid of them. You just have to keep them there indefinitely because of the union protections. The district court also found that the balance of hardships and public interest favored plaintiffs because the government had deferred implementation of the aspects of the order and because they found the collective bargaining agreement is in the public interest. So the judge decides this is good for you. And you're going to have these people who can continue to work there and they're going to continue to have their contracts and their benefits because of the First Amendment. And the government can't get rid of them. The government filed emergency motion, said, are you nuts? On July 7th, the Ninth Circuit granted the government's request for a stay pending our consideration. And now we grant Trump's emergency motion for a stay. We review the factors here. Was this a strong showing? Or are they going to succeed on the merits? Is there going to be an irreparable injury? Is the issuance of a stay substantially, does it injure the other parties? And where does the public interest lie? Well, here's what we've got. A plaintiff claiming First Amendment retaliation, like these unions are, must show that it was engaged in a constitutionally protected activity, which I guess to them is like collective bargaining with the federal government so they get contracts that are satisfactory to them. That's now a constitutional right under the First Amendment. Says Trump's actions would chill a person of ordinary firmness from continuing to engage in the protected activity, I guess of having a collective bargaining agreement. Now, the protected activity was a substantial or motivating factor in the conduct, so I guess it's more like it's a penalty for speaking out. Now, if they show that, the burden then shifts to the government to show that it would have taken the same action, even in the absence of the protected conduct. Now, the district court didn't address that issue, just kind of skipped the second half of the test. So we just kind of look at the first half and then doesn't go back to the government and ask, well, does the government have a good reason for this? Like, is there another justification independent of this? Like they say it's an attack on them. Does the government have another good reason for why they're doing it? You have to look at that. The judge didn't do that. He just said, well, it looks like an attack. That's good enough for my analysis. Let's call it a day and go to the beach. We conclude the government has shown that it is likely to succeed on the merits of the retaliation claim. It's not retaliation, even assuming that they have made out a prima facie case of a claim of retaliation. On this record, the government has shown that Trump would have taken the same action even in the absence of the protected conduct. In fact, on its face, the order doesn't express any retaliatory animus at all. Instead, it conveys the president's determination that the excluded agencies have primary functions of national security and they can't have collective bargaining unions. Now, for their parts, the unions rely on the statements in the fact sheet, but the order and the order's broad scope and the order's carve-outs for law enforcement offices within the excluded agencies, including the Bureau of Prisons, like we've made exceptions, whose employees are represented in collective bargaining by one of the plaintiffs. And, you know, the Bureau of Prisons are amazing, aren't they? Man, they're so good. We're really glad they've got unions in the Bureau of Prisons so that the video cameras work and we can see everything and guards aren't falling asleep and inmates aren't being murdered in their cells when they're some of the highest profile people in the world. We need more unions, actually. We should double down on unions for prisons because they're so good. We will assume for present purposes that it may be appropriate to look beyond the facial neutrality of the order. But even accepting for purposes of argument that certain statements in the fact sheet reflect a degree of animus towards the unions and their first activities, the fact sheet, when you take it as a whole, demonstrates the focus on national security. So you got to read the whole thing, not just those cherry-picked statements from you. The fact sheet first explains that excluded agencies and subdivisions serve national securities in areas including national defense, border security, foreign relations, energy security, pandemic preparedness and response, cybersecurity, and more. It also says that the law, according to Congress passed in the 70s, allows unions to obstruct agency management, including by stopping the removal of poor performing employees or people who commit misconduct. They just are allowed to stay indefinitely, which is the contrary to the need for a responsive and accountable civil service to protect our national security. The fact sheet thus conveys that the EO advances national security by curtailing union activity that undermines the agile functioning of government offices with national security related missions. In other words, the fact sheet conveys an overarching objective of protecting national security, and it has an assessment that the union bargaining impedes the functioning of the agencies and their national security related responsibilities. Pretty clear. Now, they also rely on the broad scope. They say, well, Your Honor, it's too broad. There's a jagged line drawing to demonstrate animus. They say the order is over-inclusive. It covers agencies that are not national security agencies, and it's exempting certain law enforcement employees in certain other areas. So the court says, well, we question whether we can even take up these arguments. They invite us to assess whether the president's stated reasons for exercising national security authority, which is clearly conferred to him by statute, were pretextual, is what you're asking us to do. So you're kind of asking us to say, well, the president said it's for this thing, and the law says he can do that and say it's for these things. And the law is very clear, and all the other presidents have done this, except Biden. And a bunch of statutes exist, and case law exists. And so now you just want us to say that if we've analyzed what he said, that it's just not real. It's just a pretext. and just invalidate the sitting president? What? But even if we assume the order's line drawing could constitute some evidence of targeting, on the record before us, the order reflects that the president would have taken the same action in absence of the protected conduct. And the order in itself, the fact sheet, fairly indicate the president would have issued the order regardless of their speech. Okay, they didn't have to talk crap about Trump at all. He would have done this anyways. Based on the perceived impact of the union activities, the collective bargaining, and how it impacts the operation of the agencies. Now, the government, writes the Ninth Circuit, has also established a likelihood that the government is going to suffer an irreparable harm if there is not a stay. That is a shift, man. We never hear them find that. As the DC Circuit explained in another case, right? So they did the same in staying an injunction of the same order. Although the government has deferred implementation, the government suffers irreparable harm, even to the extent that the injunction overlaps because it ties the government's hands in the national security context. And as the Supreme Court recently reiterated, anytime a state is enjoined by a court from effectuating statutes, that is an irreparable injury. Trump versus Casa case, we read through that one a lot here. The government supporting declarations reinforce its assertions of irreparable harm. A declaration from the State Department that was attached here states that this injunction risks slowing the reallocation of resources to protect American citizens abroad. We can't charter evacuation flights, we can't facilitate overseas communications, and we got other programs that are supporting national security. And so the remaining factors also favor the government. Sorry, unions. Whatever harm to the collective bargaining rights that they're going to experience due to a stay is mitigated by the direction to the agencies to refrain from terminating this until litigation has concluded. So it's on appeal. So your agreements are still good. And it is something that you can, mitigate right now. Go find other jobs, find other sources of funding, whatever you got to do. Moreover, any terminated agreements can be reinstated if you guys win. It's also speculative whether they will experience harm through weakened support for unions. Like, what the heck? Why are you entitled constitutionally to have your little, communistic type of entity supported by federal dollars? And of course, in other cases, and how a paused administration of dues can be addressed by voluntary dues payment in the interim. Okay, just have your own people pay out of their pocket. Don't siphon it off their paychecks. Finally, staying the injunction will serve the public interest by preserving the president's autonomy under the law that expressly recognizes the national security expertise. And so for the foregoing reasons, the Ninth Circuit says, we grant President Trump's and the DOJ's motion for a stay of the lower level court's injunction, and the unions are blown out. So good news over there. Shout out to the Ninth Circuit. The unions may appeal that, but all of this, of course, this is just an initial stay essentially. So we'll have more litigation, more briefing, but happy to see the Ninth Circuit recognizing that the president has power and there's a presumption generally of good faith and comedy between the two branches, like friends on the same team. And the unions are not entitled constitutionally to all these government benefits. They can go find other ways to grift.